Ladies and gentlemen, I'm Wade Murray, and she's not getting the text, so something to do with some kind of issue there. We'll figure it out maybe. Ms. Robinson, good morning. You're here for first appearance accused of one count of aggravated battery with a deadly weapon. Ms. Robinson, there is probable cause for the charge. Ma'am, I've looked at your criminal history, which is very lengthy. I've also looked at your history on the Department of Corrections website, which shows that you've been to prison 8 times. Ma'am, is that accurate?
I understand what you say.
You've been to prison 8 times?
Yeah.
Yes. Yes, Your Honor.
Okay. So, Ms. Robinson, I'm going to set you a bond. I can't give you a conditional release in good conscience with that kind of history, but I do want to see if the attorneys have any additional information I need to be aware of. Mr. McDaniel, anything?
I'm not aware of anything, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. McDaniel, Mr. Mitchell, I'm going to set our bond at $25,000 cash or surety. Ms. Robinson, that means you can go through a bondsman if you wish. Ma'am, you do have a condition of no contact with the alleged victim. So, Ms. Robinson, you can have no contact with the person that's accused you of this. And you will get to use the phone in just a few minutes, ma'am, to try to post the bond. Ms. Robinson, do you have any questions?
Who is the victim?
Did she
Your
say
Honor,
who is the alleged victim?
Sure. Yes, Your Honor.
All right, that's a fair question. Let me get that information for you. I looked at the file this morning. I read the complaint, but I did not write down the name of the alleged victim.
Well, Your Honor, who is the witness?
Ma'am?
Okay, hang on. Hang on.
Okay, this is a cutting and stabbing incident that allegedly took place. Ms. Robinson, don't comment on it now. I'm just trying to give you some more information to answer your question. This incident supposedly occurred. There's been a warrant out for you since April. The incident supposedly occurred in April, and it supposedly occurred at Chipola Mart, Mariana. The alleged victim is a Kiana Williams. Miss Williams is the person you could have no contact with. Any other questions?
Where's Chipotle?
It's the gas station across from McDonald's. Okay? Anything else? Good luck to you, ma'am.
After Miss Robinson, we have Melissa Harrison. Miss Harrison, good morning. Miss Harrison, your case is a little bit confusing to me because you're on conditional release in Holmes County, but I can't tell if you came from Holmes County. So have you dealt with a conditional release violation or not?
She come from Washington County. She still has pending charges in Washington, Holmes, and Jackson. But she's going to, it's going to be some kind of global fee. Not Washington.
No, Bay County.
Bay County. So it's going to be some kind of global fee. We're already working on it. So just ask for bond.
Fair enough. Mr. Mitchell, anything?
No, Your Honor.
Ms. Harrison, there is probable cause for these 2 charges. I'm going to set your bond at $1,000 cash in each case, but you've got no bond for 10 days because it appears you're on release out of Holmes, and these charges allegedly occurred after that release. You do have an active Bay County warrant that I saw in the system this morning. So if you post bond here, be aware of that. You're probably not going to be released. I'll see you in 10 days. We'll see if they revoked your bond or your release in Holmes County. And it sounds like Mr. McDaniel's, someone's got you working to try to get everything resolved. Ms. Harrison, do you have any questions?
No, sir, I don't. Thank you.
All right, ma'am. Have a good day. Mr. McDaniel, let me see Mr. Phillips and Miss Land last because her attorney may be logging in. That'll bring us to Michelle Phillips.
She called me and she said she may be a few minutes late, but she was going to be in the courtroom.
Okay. She's coming in now. So as soon as we get through with Miss Phillips, we'll deal with that case. This is State versus Michelle Phillips. Miss Phillips, good morning. Ma'am, you're here on a truancy pickup order, ma'am, regarding truancy court. Judge Garcia has asked that you be held until she can get you back in front of her in truancy court. I'm going to ask Mr. McDaniel to notify. I think that's Miss Simpson that does truancy court for y'all, Mr. McDaniel.
Nobody does.
I believe Miss.
I don't think anyone does. That's a civil case. That's a civil matter.
Okay, in that case, I'm going to ask you to notify Judge Garcia's office. In fact, I saw Debbie in the hallway this morning. So Miss Phillips, they'll get you on the upcoming truancy court docket, get you in front of Judge Garcia, but you have no bond for the time being. Miss Phillips, do you have any questions?
No, sir.
Have a good day, ma'am.
Judge, can we do Phillips and Land last? Because I know they're a little bit more complicated.
Sure. Brandon Williams is next.
Hey, everybody. Welcome to American Courts Live. We got some new court today. We got a court from Boulder, Colorado. Got a 1 hour long hearing on a $20 parking ticket. And so I don't know if we're going to get to that one, but we've got a another 30-minute long one that's good. It's got to do with bodily injury, threatening bodily injury, and the guy that just don't get it. I don't know if it's misogyny or if he's just an idiot or if it's a cultural difference, but we'll determine that together. We'll say hey to everybody. We got a good little crowd in here tonight. Tonight at 10:30 my time, so it's 9:30 Austin time. 9:30 over at American Courts 2. We're going to have a live with Court Addict with Ali ATX, or ATX Ali, however she says her name today. So let's get on with the Boulder one and let's see where that goes.
Mustafa case that's scheduled for a jury readiness conference for today's date. Perhaps we'll start with Mr. Reynolds. Are we ready to proceed from the city attorney's office for the jury trial?
Yes, Your Honor. I will just note that our office filed a motion to add 2 charges to this case earlier today. We are moving the court to add the charge of threatening bodily injury and use of fighting words.
All right, let me pull up the motion.
And Judge, while the court is doing that, I did attempt to advise my client of those charges, and we weren't able to get through that. So I would ask the court to advise him of those additional charges.
I'm going to need to do that, obviously, then. Okay, so do you want to take a position with respect to the motion to amend?
Your Honor, I will let the court know that I was having a bit of trouble communicating with my client as we were talking earlier today. So I have some concerns.
Okay, why don't we have you raise those concerns for me then now, because I do want to be able to address the motion to amend.
Well, as I just expressed to the court, I was attempting to advise him of those charges that the city attorney would like to add, and I was not able to get through that conversation with him. I spoke to Mr. Reynolds. I do have some concerns about my ability to communicate with him and his ability to assist in his defense because we are having trouble communicating. I don't know if that's something that's temporary for today. Obviously, I haven't filed a competency motion because I kind of wanted to see how this hearing went. So I guess at the very least, I might ask for some additional time to talk with him about those added charges.
Okay, why don't you do that? I'm inclined to, because of the rules of procedure do allow for a motion to amend to be filed anytime prior to the trial date. Obviously, I would have to advise and take pleas on those additional charges, and that might impact whether we go forward with a jury trial on the existing date or not, because speedy trial could start anew on those 2 new charges, but we could have some discussion about that as well. So do you want to take a break right now?
I don't think that me speaking with him today is going to be helpful.
All right, so Mr. Mustafa, you've heard Ms. Talene talking about your case, that she's having some difficulty talking to you about your case. Do you want to respond to that?
Yes, that is a biased opinion. She asked me to go out to the room, which we did. Then she asked me to wait because she was texting someone else, whomever, I don't know, it's not my business. While I was waiting for her texting that person, I was carried away. I was looking at the wall, at the ceiling. I don't know, just keeping myself busy, not to get involved with her doing, so to say. After she was done with texting, she looked at me and she's like in elevated voice, she started talking to me. I explained that she doesn't have to raise her voice at me. And she said that I'm not paying attention. I'm looking at the wall. I'm looking at the ceiling. And I explained that while I was doing so, she let me know that she is busy texting or doing whatever business which is not affiliated to my case specifically. And this is the conversation she's bringing out from the room, saying that we couldn't have a conversation and she didn't have a chance to explain about additional charges which were added to my case. It doesn't make sense. Yes, you didn't have a chance to explain because you were busy first texting another client, as you mentioned it, and then you were busy raising your voice at me for no reason. I didn't even understand for what. I mean, what did I do wrong to you?
Okay.
Then she just walked away from the room, and that's all. It was done, basically. She came and she sat here, and now you are having the conversation you are having. That is the case, basically.
All right, so a bit of a conflict today.
Conflict, I didn't even have a chance to express myself verbally in one way or another. As I mentioned previously, she was busy doing her thing. I mean, I cannot be like forcing myself upon someone if she's busy texting another client while she's in the room with me, and the concern should be like concentrated within my context.
Well, let's take a moment then. There doesn't seem to be anything that prohibits you from having a brief 5-minute conversation with her right now.
She's right that this conversation wouldn't go far.
Why not?
Because it was such a I mean, she walked away from the room like something happened.
Why can't you have a conversation with her now?
She represent me.
Ms. Talene, are you willing to represent the defendant?
Yeah.
All right, so Mr. Mustafa?
You are being dishonest then?
I am not being dishonest. I did not say that.
But you created that impression when you walked out from the room without saying anything, that you're not willing to represent me.
Are you willing to have a conversation with her, Mr. Mustafa, about your case right now?
I don't think this is going to go any further. I mean, after this, what she said, it wouldn't register within my conscious mind. I wouldn't be able to fake any type of conversation.
You're not going to have a conversation with her?
I'm sorry?
You're not going to have a conversation with her when she's willing to have a conversation with you about your case?
But we had a chance, though, and it didn't go far.
It is not the court's job to mediate conflicts that you might have with your lawyer.
I don't even comprehend the reason of the conflict.
Doesn't seem like there should be a conflict.
With me.
You may not have liked the fact that she wasn't talking to you directly in that moment, but she's providing she's providing you the opportunity to have a conversation with her now about your case. And I don't see a good reason why you should not have that conversation. If you do not want to be represented by a lawyer, you can indicate that, but this is your lawyer. This is the lawyer that I've appointed in your case. If you want a lawyer to represent you, you're going to work with Ms. Talene.
But in this case, our relationship is forced by a court itself.
I'm not forcing a relationship. I'm giving you the opportunity to have counsel. And the court's going to pay for your counsel. That's right. But I'm not forcing that. If you want to have a lawyer represent you, it's Ms. Talene as your lawyer.
Okay, which is my other option?
To represent, you can represent yourself. You can represent yourself in the case if you choose to.
I will express myself verbally and I will say everything what I know, which is related to the case specifically. Ever since you've assigned a lawyer or, the defense to me, we haven't met. I mean, we haven't had any conversation over the phone, over the text message, email, any other type of conversation.
Okay.
So this is basically second time I had a chance to see her.
Right.
And which didn't go far. So
But you're prohibiting it from going forward right now.
She's incompetent about the case. She doesn't know what is going on. We haven't had personal conversations ever. The last one a few minutes ago failed. So, I mean, I would have a good chance just to explain myself in the best way possible, that's all. It would be the best choice since she doesn't know and I do, I mean, it related to me specifically.
Okay. All right, I've heard from the defendant. Ms. Talene, if you're suggesting that the defendant's position here constitutes an inability to assist in his own defense that would constitute a competency challenge, I don't have that in front of me. I have someone who perhaps doesn't want to interact with you in the way that you want to interact with them, but I don't view that as a competency issue from my perspective. I don't think it's been raised such that I could rule on it.
Well, and as I said, this sort of came up this afternoon, so this wasn't something I had been planning to be discussing.
Right, okay.
Yeah.
But we do have a problem because it appears to me that Mr. Mustafan is not willing to have a conversation with you about his case. Is that right, Mr. Mustafan? You do not want to have a conversation with Ms. Talene at this point?
Well, going back to my previous experience, which we had just had a few minutes ago, I'm recalling unpleasant experience, which is incompetent from her behalf. You know, she's not as, she doesn't behave as one could have expected, specifically within the judicial field. And yes, I'm willing to say things on my own behalf. Yes, I'm expressing myself verbally for my own case.
You're expressing yourself right now. The question that I
But
have.
the hearing, though, did it start yet, or we are still like?
We've called you.
It's at 2 and we are at least 40 minutes late. Over here, it says 2.
That's right.
Jury readiness conference.
That's right.
I don't know. I don't know how it works. In my opinion, if it says 2, it means 2 exactly. Over here, we are already.
Well, you're not correct in that.
That's
it's 2 o'clock for you.
It's double check if we are in a conference or this is a pre-conference. What is this?
Let me explain that.
Thank you.
Right. You are scheduled to be here at 2 o'clock.
Okay.
All right. The court does its best to see cases in a timely manner. It doesn't mean that when someone's scheduled at 2, right at 2, the hearing's going to begin. Because at 2 o'clock, there may be conversations that the prosecutor wants to have with the defendant and the defense lawyer. The court may be engaged in another case at that time. So the case has begun. When I called your case forward, that's when this hearing began.
So about a little over 10 minutes ago?
That's perhaps correct.
Okay.
So the case that we begun the discussion about this jury readiness conference. The purpose of a jury readiness conference is determine whether the prosecution is ready to proceed with their case and whether the defendant is ready to proceed with their case for the jury trial that is scheduled on another date. And as part of that jury readiness conference, the prosecutor's responsibility is to, if they have legal issues that they want the court to address, they raise those legal issues with me. If the defense has legal issues that they want me to address, the defense can raise those legal issues with me. It's also the last opportunity for people, if they're going to have a plea bargain, a plea agreement that they reach, that they present that to the court. So all of that is part of this jury readiness conference. And so when Ms. Talene is meeting with you, and perhaps she's having conversations with the prosecutor, she's trying to get a handle on what's going to happen next, what your interests are, what the prosecutor's interests are, what legal issues are there. And so that's what the purpose of this is.
In order to resolve everything what you have just said above, we should be meeting more often and just because on the first hour meeting, I've explained that I do not use phone, I do not use texting, I do not use email, I do not use any other type of communication. The best for me is to come over to the courthouse itself for a meeting.
And you're here today.
Yes.
And I'm offering you the opportunity to have the meeting.
Go well.
But you can still have that meeting.
Of course it had to be muted. Okay, if everybody will say muted, I'll know it's muted. Thanks a lot, Fozzie. Okay, Artie, I'll go ahead and get Art. I'll get started again on this one. Fighting words. They basically got him for saying something fussy with someone else. The judge will explain it to him just a little bit. Yep. I got everybody. Is it still muted? All right, we're going to hit play because it tells me I'm making noise.
You could still have it. We're running out of time because it's at some point Ms. Talene has another court appearance, but you could still have a 5 or 10 minute conversation with her right now. But it sounds like you're refusing to do that.
Nothing comes into my mind. I don't know what to say.
The first rule on the motion to amend. I'm going to grant the motion to amend the add to 2 charges. And then I'm going to advise the defendant of those 2 charges. And then we're going to go from there. So the prosecutor has filed a motion to amend to add counts 2 and 3. 2 will be threatening bodily injury, which is a violation of section 534 of the Boulder Revised Code. And then count 3 would be use of fighting words in violation of section 536 of the Boulder Revised Code.
I would like to be specific. If someone came up with such a charges, I would like to know what did I say to whom? And
hold on a moment.
When?
Hold on so I can step through this one thing at a time. All right. I don't want you to interrupt me while I'm advising you of the charges, and then I'm going to tell you what they are, and then we'll go from there. So I've told you what those 2 charges are. They both allegedly occurred on August 27th of 2024. Understand those 2 charges. I can read them to you if you'd like.
I wouldn't make such a claim. I am guessing what is happening over here, but no. And it's not related to my competence.
So they've alleged that you violated, the first charge was a trespassing charge. They've added 2 charges. I've granted their motions to amend. And now I'm telling you about those 2 charges. And as I mentioned, the count 2 that they've added.
Who did I threaten to do anything?
They haven't indicated that yet. They've simply indicated that the count 2 is now a charge of threatening bodily injury under section 534 of the Boulder Revised Code. I'm going to read that ordinance to you.
Okay.
The charge of use of fighting words is a violation of section.
To be specific within the context as well, if you came up with such a charges, I want to know the details.
I understand you want to know the details.
Yes, thank you.
That's not my job to tell you the details. All right.
What do you mean it's not?
My job is to tell you the charge. All right. And where it's my job is to tell you where it's alleged that this has occurred.
So you are judging me without knowing the details?
No. I'm telling you the charge. I'm not judging you. I'm not judging you, Mr. Mustafan. I'm telling you what the charge is. It's merely an allegation. It doesn't mean you committed the charge. I'm just telling you what the charge is. Now, at some point, it's an accusation. It's an accusation only. Use of fighting words says that no person shall, with the intent to harass, annoy, or alarm another person, repeatedly insult, taunt, or challenge another person in a manner likely to provoke a disorderly response.
The only people I had a conversation with that night specifically, it was police officers. That's all. I haven't had any other conversation with any other person.
Understood.
And everything what I've said, it was based on emotional state of mind. That is first. Second, I'm responsible for everything what I've said to a police officer ever in my life. And I'm responsible for what I'm doing.
Okay.
And
I'm going to remind you, I'm going to ask you again to let me finish telling you what the charge is and then asking you how you'd like to proceed with that charge. Okay.
This is not an actual court. This is a jury readiness conference. It means conference. I'm here to communicate about the case or on behalf of the case.
If you are not going to listen to me, we're going to have a great deal of trouble. All right. I do not want to be in a position where you continue to speak when I'm asking you to listen. I need you to listen so I can tell you.
You're threatening me then?
I'm not threatening anyone. I'm telling you.
You said a great deal of trouble.
We're going to have a trouble with getting through your case.
A great deal of trouble is expandable. for you.
Mr. Mustafan,
Let's see how far it's gonna go.
Mr. Mustafan, I do not want to have to do anything other than tell you what your charges are. That's all I'm trying to accomplish. But you're making it very difficult. You're making it
What does
difficult for us to get.
conference mean? Conference mean is communication on behalf of the case, which is related to the context specific.
No, this is a time for the parties to confer with the court and let the court know whether or not they've reached a resolution and whether or not they're ready to proceed to trial. It is not a time for you to go talk about the details of the case. This is not that time, actually.
It's
No,
related to me. How do you mean?
it's not. I'm telling you what the rules
I have
are.
a right to ask you about the details of the false accusation.
Not today you do not.
Specifically,
Not today you
which is
don't.
related to my case.
Not today.
Specifically. Not today, when? When I come back on the court day?
Yeah, on the jury trial date, you'll have the
So
opportunity.
then I'm gonna be able to express myself.
Yes, you are.
And talk on behalf of the case.
Yes, that's
But
right.
today, I'm just listening.
That's right. And being advised of what the new charges are. Okay?
What do I know? I know nothing.
So let me go over that charge with you. The charge is use of fighting words. I've described it. It says no person shall, with the intent to harass, annoy, or alarm another, repeatedly insult, taunt, or challenge another in a manner likely to provoke a disorderly response. That's the allegation that the prosecutor has made against you. They say that that's what occurred on this original date in Great Park.
No.
Do you understand the charge?
Over here, it's not Chautauqua, it's open space mountain parks. It's two separate properties.
Do you understand the charge?
City of Boulder, but it's not the same thing.
Do you understand the charge? Do you understand what he's
It's
alleged?
amazing the way you speak. If you have to be precise, specifically within the judicial field.
I think I'm being pretty precise.
I don't think so.
I read you the charge. Do you understand what the charge means?
So next.
Do you understand what it means? Do you understand what it means?
Okay, I got the point. Next.
No, but my question is, do you understand the charge?
Yes, but I do not plead guilty.
That's fine. That was going to be my next question. How do you plead to that charge, which is count 2 of use of fighting words? How do you plead?
I plead no guilty.
Okay, that's fine. The third charge and it's the second one that's been added is a charge of threatening bodily injury. And I'm not saying you're guilty. I'm simply saying this is the charge. It's an allegation. The allegation is that you threatened bodily injury in violation of section 534 of the Boulder Revised Code. You understand that charge of threatening bodily injury?
I plead no guilty.
Do you understand the charge? You're nodding your head. You don't understand it. Would you like me to read what the ordinance says?
Well, I'm assuming that it says I've threatened to kill someone, yes?
Let me tell you what it says. No person.
Specifically a police officer?
Let me tell you what the ordinance says.
Okay, that's fine.
No person shall knowingly, by threat or physical action, place another in fear of imminent bodily injury. Do you understand that charge?
I do.
Okay, and how do you plead to that charge?
Not guilty.
All right, we're getting there. All right, so now I've accepted not guilty pleas. So there's 3 not guilty pleas that have been entered on the 3 charges that are pending.
And everything started with me trying to get water from the water fountain. And this is how far it has come. It's amazing. It is amazing. To me personally, yes. From someone who came from another country, yes.
All right, let's
I'm
talk.
stating it to your face. I have no respect to a police officer. And everything what I've said, I'm responsible for it. And that conversation, everything what he came up with is from within that conversation.
Okay,
Okay.
so let's get back to where what we were talking about before. We're now in the position of you having pled not guilty to the 3 charges that are pending. Right now, the case is scheduled for a jury trial for November 14th.
Okay. At 8.
That's right.
Okay.
The question that I have is, right now, Ms. Talene is your lawyer. She's the one that will represent you at that trial.
I don't know how far it's gonna go. I'm not sure. Do I have another option?
Do you have another option of,
No, I'm asking if I have an other option.
yes,
Or, I mean, can I get someone else? Because I don't think we will get along. Just the way she treats me. She doesn't have to raise her voice at me for no reason. I haven't done anything wrong. It's the same over here. I mean, first, she makes me wait while she's communicating with whomever. It's not my business. Second, when she's done texting, like suddenly she woke up and started yelling at me for no reason. Yo, I mean, would you please have a respect?
so if I'm understanding you correctly, you're suggesting that you have what the court calls irreparable differences between you and your lawyer, so such that she can no longer represent you. Is that what you're saying?
Or I wouldn't want her to represent me because that is my conscious choice.
You do have the right to choose between whether you are represented or not. In our court, you don't get to simply say, I don't like this lawyer, so I want you to appoint another lawyer.
But
It doesn't work that way.
Alone, though. I mean, she wouldn't even give me a chance to say anything. She just walks away from the room as soon as I ask her not to raise her voice at me. That's all I said, basically. Did I ask something like extraordinary? That I dislike when someone yells at me? Is it inappropriate within the judicial system of United States?
You have come to the conclusion that she's mistreated you. I understand that's how you feel.
Listening how she presented herself in our relationship at the very beginning, yes. This is my personal perception.
Right.
Thank you.
I, of course, wasn't part of that. I didn't see the interaction.
You are busy doing your thing. I mean, I don't have much to. I didn't expect you to be there. I'm explaining myself.
What I'm telling you is I can't simply say, oh, that must be the case, that Ms. Talene didn't listen to you and that she yelled at you and that justifies me putting someone else in the position of being your lawyer. You've said that. I can't conclude that.
I'm not defending myself. I'm just expressing my perception.
I understand.
Judge Khan, I'm just letting you know that the district court has asked me if it is at all possible to go upstairs because there's apparently several very lengthy sentencings.
And are you scheduled to be there at 3?
Yes.
See, her timing is precise. 3 is 3. My timing says 2, but it's gonna start at 2:30. It's not precise.
I mean, if I need to stay down here, that's what it is, what it is.
I think we need to reset the case.
Her time more than you care about my time?
We're going to reset this hearing.
Oh, okay. Got the point.
And then I'm going to look on calendars. I'll start with Ms. Talene and Mr. Reynolds. Are either of you available next Friday at 2:30?
Yes, Your Honor.
Give me one moment, please. Yes.
Okay, so we'll reset this for next Friday at 2:30.
Which is the date?
Friday, the 18th of October. And we're going to give you a written setting notice. You'll have something in writing from our clerk. We'll give you, Ms. Talene, an opportunity to file any motions that you think with respect to whether or not the court should allow your withdrawal or require your withdrawal. And Mr. Reynolds can respond to that. So if you can file that early next week, and we'll give Mr. Reynolds a couple of days to respond, just so I have something in writing to address the legal issues that are before us.
Yeah, and I think I could probably get something filed by Tuesday. Monday, I'm dealing with some bad stuff.
Let's just make Tuesday at 4 PM
Okay.
the deadline for you, and then we'll
Yeah.
give Mr. Reynolds Thursday at 4 PM to be your response, if any. Mr. Reynolds to that. And then I can address that issue next Friday. I need some time to think about this. There's obviously a disconnect between you and Ms. Talene, and
No, there is a disconnect between me and the judicial system, the whole thing.
that may be true as well. I get you.
Thank you.
But we have to figure out a way to get you through your trial and have you fairly represented. And I don't know whether that means having you proceed on your own or whether it means,
To me, I have to be honest.
And Judge, I
Just
am
going
sorry,
back
can
to
I?
everything what I've been through here, and just to this specific case that I was trying to get water from the water fountain, which is outside, and how far this has come. That is mind blowing, man. It's amazing to me. It means that you do not make me a better person. That's all I got.
okay.
And there is a price. A hefty amount. Someone would have to pay. As you make me pay, I will make you pay. You don't even look at me because
I'm listening. I'm listening. I'm not afraid. I'm just writing.
And Judge, since I have the date, would it be possible for me to run upstairs? Since I have the next
Yes,
date,
you can
my
leave.
deadlines.
Yeah, at this point, we're just resetting it for the hearing. We've got the dates.
Okay, thank you.
Are we done? This is it?
I want you to hold on just a moment. Are you gonna print out?
I printed it, give it to him, yes.
And he's already got his signature on it?
It's amazing.
A quick signature right there for me, just indicating you know that you're gonna be here.
I will be here.
Okay.
All right, I'm going to make sure I get that one next week. Make sure someone reminds me. Jay, that's your assignment for next week. A lot of talk was about the cultural differences and whether it was a cultural difference or whether it's not. If it's not a cultural difference, that's just an area where people that come to our country are going to have to figure it out. We're a welcoming country. We love everyone, but you can't come over and expect us to understand every custom everywhere. He's got to figure it out. I don't like the idea of fighting words. I don't. I think he got arrested for something similar to criminal mischief. I think they just wanted to be done with him. He wanted to argue with the cops all night, and so they just said to hell with him and just go ahead and put him in jail for the night. And this is the result of it. DSN thinks it's a joke. I think he has a point. I don't think he knows how to communicate, and I think he needs to shut up and let his lawyer get it off on a technicality. But his attitude's just garbage. Username, you hit it right on. It may be a bit cultural, but it's mostly bad attitude. Absolutely, there's plenty of people here that figure it out. Well, let's jump into some. Yeah, Jay, that's a strange charter. I'm gonna start looking at that. That's a Colorado thing, so I'm gonna look at that and see what it could be. It may be a Boulder municipal code. It may be a city code. Let's look at some Fleischer from yesterday.
All right, Judge, page 21.
Okay, counsel, you ready? Come on, yes, sir.
That I can.
All right. You got me, Victoria. Linus needs to get to Houston. We need to get Linus to Houston. We're gonna put up a link for her GoFundMe, but help get Linus to Houston. If we just keep filling it up, she'll eventually make it here. Also, me and Ali ATX Ali, I can't figure out what she wants to call it. We're going to do a show over on American Courts 2 at 10:30 tonight. It's pinned over there. Everybody but Lena should be there, so we'll look from that. Victoria, I got a secret source. Don't ask Tokyo where I got it from. And so, all right, we're going to jump on that. But make sure to donate to Linus and make sure to go to that live tonight. All right, thanks.
Come on, yes, sir.
May the defendant come up here?
Yes, please. Good morning, Mr. Mosley.
How are you doing?
Mr. Mosley, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were dispatched regarding a shooting and physical disturbance at a 7-Eleven in Harris County, Texas. Officers made contact with the defendant. The defendant stated he was in an altercation with 2 employees inside. The officer entered the store and made contact with the CWs. CW1 was observed with pepper spray on his face and a hole in his shirt. CW2 was observed with pepper spray on her face. CW stated the defendant had assaulted them. Officer observed CW1 had been grazed by a bullet on the right side of his stomach. The defendant was detained and provided consent to search person. Officer recovered the handgun on the defendant. CW1 stated he was currently clocked in and was being clocked out by CW2, and the defendant was upset because CW2 attempted to clock him in early. The defendant left the store stating he was leaving, re-entered, and began disrespecting CW2. CW1 went to talk to the defendant about the disrespect, and that's when he was maced. CW2 exited the store and was maced upon opening the door, causing pain. A fight ensued between the defendant and CW1, and CW1 observed the defendant with a firearm and felt something hit him.
Mr. Mosley, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using anything, I'm going to put you in jail. You will not get any more PR bonds. Do you understand? I'm also ordering you not to be in possession of weapons and not to go back to this location. No contact with any of the complaining witnesses in this case. Understand? Of course.
Mr. Mosley is also under court supervision out of 482nd.
I see.
Court there found that there was no reason for drug or alcohol testing because this happened at Mr. Mosley's place of employment. The handgun was legal and that there was no drug or alcohol, drugs or alcohol related with this incident, Your Honor. And the court found that there was those restrictive conditions were not necessary. So we're asking that the court also not impose those restrictions.
To allow him to drink and smoke weed?
Well, keep drinking. He is a single father at home with his children. So drinking and smoking is not something he does.
And it shouldn't be an issue. If you're not drinking or smoking, then it shouldn't be an issue. But I'm going to tell you now, if you're a single father, you've not picked up an aggravated assault where there's an alleged deadly shooting. What do you think CPS is going to do when they get involved? If and when they get involved, how much do you think it's going to cost? I'm just saying, this is real life, you know?
The CPS is assured they won't get involved, Your Honor.
Really? They made contact with her already?
Yes, sir. They came out on the scene. This was his place of employment.
He was working.
Yes, sir.
Okay, you're not working there anymore, I would imagine, right? Okay.
Company called Installations Made Easy. I do go to different floor in the court,
Just be careful, Mr. Mosley. This is one life that you have. You don't have any more. Life would really suck to live in a 6x9 box for the next 30 to 40 years. It happens every single day. And it's not worth it, man. You know, really.
I'm very much a pillar of my.
So I don't want you to say anything that just against you. I'm trying to counsel you that life is so short, right? And you don't want to spend it in there. The place sucks. I'll make you a deal. If some time goes by and we know that we can trust him, then I'll take him off that type of supervision. But I want to know that that's not going to be an issue, especially if he's a single father. So if some time comes by and that we can trust him, we know that it's not going to be an issue, then come back, talk to me. But at this point, I don't want you drinking and I don't want you smoking any weed, especially with a bunch of kids in the house. Do you understand? Okay.
I understood.
I'm gonna have you sign a receipt with Victoria. We'll have you sign conditions with pretrial and then you guys are out of here. Okay? Thanks. Do you want the same date as the felony?
Yes, sir. Please. Yes. So we get that date over here.
Judge Cruz, on page 6.
Hi.
Good morning, how are you?
You have an arraignment?
Yes,
Okay.
this is my client right here.
Good morning, Your Honor. Hi. His last name?
It's, I don't know, she said.
It's under Cruz on
Okay,
page 6.
yeah, it's,
Good morning, Mr. Cruz. Mr. Cruz, you're charged with Cruz Villatoro. You're
Yes.
charged
That's
with
correct.
private
Yes, sir.
intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officers were dispatched to a crash on South Freeway after the defendant rear-ended the complaining witness. The complaining witness and the defendant pulled to the shoulder when the complaining witness pulled out a gun and pointed it at defendant, causing him to flee and strike another car. Officers arrived and observed a strong odor of alcoholic beverage and slurred speech from the defendant. The defendant admitted to drinking 2 beers, and officers conducted SFSTs at a nearby gas station. 6 out of 6 HGN. The walk and turn could not be conducted because of an unrelated leg injury, and 0 out of 4 one-leg stand. DICs were read, but the defendant refused the breath sample. A search warrant was signed and executed. And the CW in this case has been charged with aggravated assault with deadly weapon.
Gets into an accident. They pull over to the side of the road and points a gun at him, takes off terrified. Just, I guess, a normal response, gets into another accident.
No, it's just the one accident.
Oh, so he doesn't get into,
Oh, it's.
yeah, I thought you said that there was,
yeah,
gets into
he
another
drives
accident.
off. I mean, because of the gun, he.
Sure, I
and he
mean,
ends
it's,
up hitting.
and so what did the officer say? He smelled,
They detected slurred speech and a strong odor of alcohol.
okay. Did they do, you said they did the HGN?
It was 6 out of 6 HGN, 0 out of 4 one-leg stand, but they could not perform the walk and turn because of a previous leg injury.
All right. I'm gonna find probable cause now. If you find something different, come back. Show me something, you know, if you find something different, come back. We can always reproach on PC. Okay. Mr. Cruz, I'm gonna find probable cause for now. I am ordering you not to consume alcohol or illegal drugs. Do you have a valid Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
Your Honor.
Or you can continue to drive, just be careful, you know, this crazy world we live in. I mean, just nuts. You're gonna be randomly tested. If you test positive for alcohol or dope, your bond is gonna be revoked. So just don't, and then you'll be fine. You're in good hands. Elena will take care of you. Just make sure you stay in touch with her. She'll tell you when you have to come back to court. I will waive your appearance, but you must stay in touch with
I
her.
understand.
Okay? I'm gonna have you sign a reset with Victoria. After that, you go to pretrial for your bond conditions, and then you're free to go. Okay?
Thank you.
Thanks, guys.
I have one additional question.
I know you have Ms. Di.
I was about to say, she's on Zoom. She texted me this morning. You waived her appearance that she lives in Dallas.
Right.
And so you waived her appearance and she could Zoom in the
Okay.
financial difficulty. And we were approaching back to see what alternatives. Nathan did send an email and he copied the court in reference to, not Nathan, it was, I want to say it was somebody else. It was a lady that emailed that stated that we could do what you suggested about pretrial conditions, putting on bond on pretrial conditions and where she could get the monitor without cost. However, Nathan said let me go back to his email. He basically said he really didn't want to.
This is all too complicated for me. I do not have the bandwidth to engage in DWIs in this manner across this room.
This is Ms. Di from last Friday, DYE.
Okay, thank you.
This is the case. I'm sorry.
No, it's okay.
I just wanted, since I was.
Okay, yes, I got it. Thank
Okay.
you so much.
Okay, so let me reply all, and I'm gonna ask him, how would you like to go forward? And let's see, I mean, I don't know,
Well, that's what I was gonna
because
say.
remember, it's their program. I don't have,
I don't think he, based off of his email, it seems like he was like, I don't wanna deal, I mean, I don't wanna deal with it, you know, that's kind of what I gathered.
but I don't think that he's gonna enter into dismissal.
No, not early dismissed, but I don't think he cares about what you suggested, her being on the pretrial.
Correct.
Judge, they were originally asking for a 4-month extension, so she could get into compliance with the device and change it.
And what she said as long as she didn't have to come back, right? Keep coming back here, then she would be able to foot the bill for the machine, right?
That's what she said on last week, I don't know.
That's what he said.
So why don't we do, Michael, we're talking about Ms. Dye. And I don't think that Nathan is on board with the kind of informal route that we had kind of been talking about. So Ms. Dye had said that as long as she didn't have to keep coming back and forth because she was taking buses, right, to come back and forth, then she'd be able to foot the bill. So why don't we do Zoom reporting? That way she shouldn't have to keep coming back and forth, but she's got to get the machine and then extend it for 4 months, because if I remember, she had basically almost everything done.
She has all of the classes and stuff done, and it's just the fees and then the device that she has.
So I think all we're really doing is extending for her just to have the device and not no positives.
Right.
Is that okay?
Yes, I'm fine.
Ms. Dye.
Yes, I'm here. Good morning.
Hi, good morning, ma'am. Thank you for tuning in. Are you okay with that? So essentially, all you would have to do, we would allow you to report via Zoom.
Okay.
You've got to get the device back. We will extend you for 4 months.
Okay.
And then just don't have any violations. And if you can do that and you pay the fees that are required, they'll end up dismissing the case.
Okay, that's fine. So I would just have to pay the fees, and then could I start the device maybe Monday so we can go ahead and get it started?
I mean, I'm okay with that.
Yeah, if we could try to set up to get it, I could try to get the device today if you guys are able to do that.
I mean, the earlier you get it, the better. You just have to provide proof to Elena, and then she can get it to the appropriate people, and then essentially just be good for 4 months. That's all.
Okay. And am I going to be paying for it, or are you guys paying for it?
You have to pay for it. I can't.
Okay. Okay. That's fine.
I mean, I tried, and it just, there's no way to do it, unfortunately.
No, that's fine. I can try to make it work for 4 months. And then as far as reporting, I think I do have a report date coming up. So am I having to come down there, or are we going to go do that?
I mean, the idea is that you report via Zoom.
Okay.
So that you don't have to waste the money and to come over here.
Okay, that's fine. Then I can try to get the device sometime. I'll try to work on getting it this weekend and then try to start it next week. But next week at the latest, I'll be starting it.
I had her reporting that she like twice a month to submit drug tests because she didn't have a device. That was their month checks.
Got it.
So as long as
So-
she gets the device,
As long as you have the device, you don't have to test 2 times a month. Okay.
Gotcha. Yeah, that's why I'm trying to get it before they're wanting me to come down and report. That way I can just go ahead and start it.
Okay.
So can we get a date confirmation when you can get the device, Ms. Dye?
I want to say definitely no later than next Friday.
And I was gonna give a week.
Okay. All right.
So let's say the device has got to be on.
Yeah, it's Friday already. I could try to aim for it today, but then it is the weekend.
Don't
so
look.
either
Don't
today or Monday.
Don't try to do anything that you really can't. It's not a big deal. We'll give you a week. Just definitely have it done by the week.
Okay.
And then
Yeah, I can.
After that, we get confirmation. We'll just extend you for 4 months, and just make sure you don't put anything in your body you don't know what it is. because
Yes. No violations. I got you guys.
It's absolutely no tolerance. Any more violations, they're gonna kick you out.
Yeah. Okay. I got you. Thank y'all so much.
Okay, Ms. Dye.
Thank you.
Okay, thanks. Yes, ma'am. Great.
Judge, do you want to call up the Spanish arraignment?
Yeah.
I'll let- just-
Is Luis here?
Yes. Luis is in the
Right.
front.
Oh, hey, Luis.
Hey, I'm going to jump in and talk about what's going on tonight with the other show. It's called Court Addict Court Addict featuring ATX Alley. What we're trying to do is we're going to actually go through a Judge Fleischer docket, and we're going to stop and talk about some of the stuff that you can't talk about in the chat. We're going to talk about the drugs. We're going to talk about the addiction. We're going to talk about how hard it is to stop. I come to it from a different world than Allie comes to it, but I think we're both going to be able to give a good perspective on it. I think some of y'all are going to be able to relate to it, and some of y'all are going to be able to. Some of y'all are going to just be amazed, and there's probably going to be a lot of judgment, but that's okay. We don't mind it. We're just wanting to have a different conversation rather than just the general chat where, people are looking at it from their perspective. We want to kind of give different perspectives of it. And Gina, your comment right there is a perfect example of it. There's people, some of those devices are making a fortune with other people in court on the monitored devices. Absolutely. I'm spending $400 a month on an ankle monitor for my son right now. And that's $400 we really don't have, but you got to do what you got to do. And so we're going to have a lot of talk about stuff like that tonight. So it's going to be an interesting talk. Again, it's at 10:30 Eastern time. All right, here we go.
All right, Judge, page 22, Munoz, Castillo, come on up.
No, I don't know. I'm supposed to get back to this.
Yeah, so it'll be just the.
Are you Plácido Munoz Castillo?
Yes, sir.
Mr. Munoz Castillo, you're charged with, you're charged with illegal dumping. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 27th, 2024, there were photos that showed two Hispanic male suspects dumping construction tarps onto private property. The construction tarps were transported with a trailer attached to the white van. Defendant is the registered owner of the Ford van. Witness Jamie Rizzo took photos of the defendant. Officer compared the photos with the defendant's ID. The photos were clear enough to recognize the defendant. The defendant confessed to dumping of the construction tarps through a non-custodial audio recording. The officer identified the defendant through his Mexico identification card.
Okay. Mr. Munoz, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
No.
Are you in this country with or without permission?
No.
Are you in this country with or without permission?
Yes.
So, yes, what?
Sí que.
Sí. You are in this country without permission?
¿En el país sin permiso?
No, con permiso.
No, with permission.
You have permission to be in this country? What type of permission do you have?
Hace 20 años con una visa de turista.
With a tourist visa from 20 years ago.
¿No se venció?
Sí.
It has.
¿Se ha vencido?
Sí.
Yes.
Okay, so you're not here with permission then?
Y con permiso, entonces.
No.
What happens if you go to jail?
¿Qué pasa si usted va a la cárcel? I don't know.
You need to know this. It's not a smiling and laughing matter. It's a very serious matter, Mr. Munoz. What happens if you go to jail?
¿Qué pasa si usted va a la cárcel?
I want you to think about it.
Piense.
Puedo decir que pedí permiso para poner la basura en.
No, I want you to answer my question. My question is, what happens if you go to jail?
¿Qué pasa si usted va a la cárcel sabiendo de que no está en el país aquí con permiso?
No sé qué decir.
I don't know what to say.
Immigration sweeps the jail on a daily basis. Every couple hours, they are looking for undocumented and people who are not here with permission. If they find you in the jail, they will put an immigration detainer and you will sit there for the next 6 to 8 months, perhaps longer, maybe a little bit shorter, waiting for this case to be done, and then they're going to ship you off to immigration. That's what happens
Eso es lo que sucede.
if you go to jail. Do you understand?
Sí, señor.
Yes, sir.
What did I just say?
Es lo que le acabo de decir.
Que que si no estoy entendiendo esto, puedo ir a la cárcel y luego emigración y luego pues.
That if I don't follow this, I can go to jail and also then afterwards immigration.
All I'm asking
Lo
you to
único que
do
le pido
is
hacer
follow
es
the bond
seguir las condiciones de fianza de
And
esta
if you
corte.
do,
Si lo
good
hace,
things will happen. If I find that you break these bond conditions, I'm going to put you in jail. You will not get any more PR bonds.
fianza de promesa.
I'm ordering you now
Le ordeno ahorita
not to drive.
no conducir.
Do you understand?
Yes, sir.
If I find that you
Yeah.
drive and I don't care what your reason is, I'm going to put you in jail. Likewise, I'm also ordering you not to pick up any new cases. Behave yourself while you are out in my public. I'm going to have you sign this promise. This is an affidavit that you're going to sign to me, promising me that you're not going to drive. Like I said, I don't care if there's a burning building and you have to save 50 kittens. You drive, you will go to jail. Do you understand?
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. So first, I'm going to have you come up here, swear to us that you're not going to drive. After that, I'll get you to Victoria. We will have you sign a reset, and then we'll get you out of here.
I don't know who.
I have a lawyer.
Who do you have?
Garza.
Oh, they have not appeared yet. So what we will do is I can have you sign the affidavit promising us you're not going to drive. And we'll have you sign a reset, and then we can have you wait in the back for your lawyer to show up. Understand that this is the only warning that you're going to get from me. You will not get any more warnings. So I hope you heed it.
Pero de que lo siga.
Sí, señor.
Yes, sir.
Please. What page did you say?
Page 8.
Got it. Good morning, Mr. Manuel. Mr. Manuel, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officers observed the defendant driving 90 miles per hour in a 60-mile-per-hour zone across Fred Hartman Bridge in Harris County, Texas. Officers also observed the defendant failing to maintain a single lane and strike the right curb of the street. They initiated a traffic stop. Upon contact, the officers observed the defendant had red bloodshot eyes and a very strong odor of alcoholic beverage. The defendant admitted to drinking at a party before driving. SFSTs were conducted, 6 out of 6 HGN, 6 out of 8 walking turn, 2 out of 4 one-leg stand. DICs were read and the defendant consented to a blood draw. He has no prior criminal history and an eligible license, Judge.
Thanks. Mr. Manuel, I'm going to find that there's probable cause to go forward with the case. You have valid liability insurance in your name.
Yes, sir.
Now is the condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you.
Yes,
If
sir.
I find that you're using any kind of alcohol or illegal drugs, I'll put you in jail. No more PR bonds.
Yes, sir.
You understand?
Yes, sir.
Okay, we're going to reset your case to give you time to hire a lawyer. I'll have you go to Victoria Center reset. We'll get with pre-trial for your bond conditions, and then we'll see you soon. Please.
Page 9.
Double fisted. Double fisted today.
Gotta have some fun, you know?
And guys, what's up?
I've got a.
Happy Friday.
Coming on now.
Oh,
Page 9.
hey. Oh, Kennedy, that's right.
Yeah. we learned, I was talking with the clerk that it was said as like a 2B.
Yeah, well, I got it as a 2B.
But it doesn't show up on the clerk's website at all, from a public perspective. So like the only reason we knew it existed is because we came in off docket the original case. And like, I still can't pull it up now unless I go through the portal.
Is that something that they normally can see? I don't think that you can normally see 2Bs.
Because like felony 2Bs, I can usually see. Misdemeanors, I guess we just don't get them too often where.
It's really weird.
Yeah.
I don't know. Can you see 2Bs on the clerk's website?
Well, we have more access than they do. So
If I were to just like go look on anyone in the public, can they see the 2Bs for misdemeanors?
I don't know.
Yeah, it's like I can't see any of the filings in the case or anything like that, which is just, I don't know. It's interesting.
Well, I'm glad that you find out.
Yeah.
I would have reached out to you regardless to let you know about the bond violation. So.
So I know with Mr. Kennedy today, he set on the assault case. There's obviously this VPO that exists. I have spoken with the state. My intention, of course, is to ask that I am able to walk him through on the VPO. I know the state will read off their summary, of course, but summarization from our perspective is this case happened. We walked him through on Friday. You said no contact.
You did a walkthrough the first time, right?
Correct. That was on Friday. It had been out for like 2 months and we didn't know about it. With the whole 2B thing, I was able to see that one, but not this one, So they've been separated for a while. They live at 2 different houses and have lived at 2 different houses. After this, his wife wanted to tow a car that was at his house, which is under both of their names. So she reached out to the constables. The constables drove over with her in order to try and get this done. The constable met Mr. Kennedy. He didn't want to speak to the police. Obviously, having a case going on, I get it. And so told them that they needed to leave. They checked back with her and they said, "Have you guys spoke?" And they're like, "Well, he called me the other day," which was Saturday, and the cop looked at the call log and that was it. 2B gets issued. To my knowledge, based off of what I've read on the.
Did we do no contact or did we do no threatening or harassing? I don't remember.
So Manny was here for that one. I want to say it was no contact.
It's no contact, Judge.
It was whenever I had initially spoken to him before he had come, I was under the impression it would be a MOA based off of kind of how we felt everything was going to go out. But I think it went to a full no contact in court. But from what
I always ask, what the complaining witness wants. And I always want to honor what their wishes are. So if they don't want to have contact, then I'm going to do the no contact.
Yeah, and we've certainly gotten conflicting messages from how we thought it would play, let's just say.
Looking from him?
No, from the complaining witness about her wanting to proceed.
So you've been in contact with her?
So when we made contact, we go like, nope, don't want anything to do with it. Then we came into court and it was.
Just telling them something different.
Right. So when the officer looked at the call log, all I know is that he looked at a call log. And that's it. Doesn't necessarily mean that they looked at the number.
I remember reading something that he's in the middle of the street.
Yes, Judge. Yeah, an officer gets a report that he towed the complaining witness's vehicle. He goes to his address to search for the vehicle. He doesn't see the vehicle.
1 second. A vehicle gets towed from whose house?
The complaining witness was staying with her sister. She calls officers and says that he owns a tow truck business and thinks that he towed her car. So the officer goes to his house to see if the towed car is there. He drives past once. He's standing out in the yard. He drives back.
And we're talking about he's in his house now.
Yes, he's at his house. The officer drives past his house. He's in front of his own house in the yard. Officer comes back down the street and he's standing in the front of the road and starts yelling at the officer.
And at least from our perspective, he owns a body shop, not a truck company. And the officer had come down the street and had said, "Oh, Mr. Kennedy," and he came out to the street set. And that's when essentially there was some yelling.
So the only reason for PC is the alleged phone log.
Yes, Judge.
How do you know he did it?
The complaining witness showed the officer the call log, which showed.
Right, but it's a call log, right? Did she actually speak to him? Did she say she spoke to him? How do we know it wasn't his brother that made the phone call?
And also to add to that, Your Honor, I can always change my wife's phone number to say Domino's
Right,
Pizza.
there's so many phones that can spoof, you know, there's so many vindictive people in this world, it's unreal. So, you know, if she tells the officer, yeah, he called me, I spoke to him, and it was in violation of the no contact order, then yeah, there's probable cause. But if we have just a phone call and we don't know, just a log and nothing else.
Allow me to read directly from the DIMS, Your Honor.
Sure, of course.
The complainant advised that the defendant had called her at approximately 1:30 hours to ask her to call the district attorney's office to drop the assault charges. He also called to tell her that he did not.
Okay,
do
that's
anything
what,
for her.
okay, now that's clicking in. So he calls her saying, hey, man, drop these charges.
Yes, Judge.
What was the date of that?
The date was.
Did all the conditions on 10-4, by the way.
I don't see another date alleged besides the October 5th date, Judge. So
This is the phone call with the log, right?
Yes, Judge. And then she showed the officer the log as corroborating evidence.
See,
Your Honor, strictly if I have an individual who is certainly mad that she wants access to a vehicle so much that she's had a constable come out, I would put that past somebody who could change somebody's name in their phone to make it look like they called.
If we had just a phone call log,
right,
I was going to find no PC.
Right.
But if she is saying in the sworn statement that he made a phone call to her the day after he had court, telling her to drop the charges, I mean, that's a violation. And remember, this is only probable cause. So by
Yes,
no
Your Honor.
means does it mean there's beyond a reasonable doubt.
And I understand with that. And at least in the alternative, I'd ask that, you know, a bond be set so that I can have a
I'm
bondsman
going
come
to
up
set him a
here.
bond, but I'm not giving him 2 walkthroughs. I gave him a free walkthrough once. The day after he allegedly makes a phone call trying to obstruct. No, I'm not. It's not going to happen again. And I'm going to tell you now, I'm putting conditions on this bond now. And I'm going to tell you now, the Texas Constitution does not allow me but in extremely limited circumstances to have a hearing to hold someone at no bond. 0 bond. This is one of those occasions where I'm going to put conditions on your violation of protective order. You violate conditions, I can have a hearing to hold you at no bond. And I will do it in a heartbeat to protect every person of this county. Do you understand, Mr. Kennedy? I don't care what your excuse is. I don't care if Mother Teresa tells you to make a phone call. You violate conditions. We will have a very, very disturbing hearing. Now, I will not put an ankle monitor on at this point because all we have is a phone call, right? If we had something more overt, like he's going over there or doing something like that, then I would take further action like ankle monitors, curfews, and the like. I'm not going to do that at this point, Mr. Kennedy, but I'm going to tell you, any more issues, it's going to go really sideways real quick. Do you understand? Okay. Bond recommendation.
I believe that $10,000 surety bond, Your Honor, will be sufficient based on the fact that a single day after he received conditions to not contact the complaining witness in an assault family member case, he did so in an attempt to get her to drop charges and obstruct justice.
Your Honor, I believe that used to be the bail schedule for a second-degree felony. I would ask that bond be set at 1,000, given the nature that this is simply a phone call. Mr. Kennedy and I will, of course, be in very tight communication about him staying in line with his bond conditions. I will personally make sure that I check in with him weekly to make sure that he is not making contact. But I think setting an oppressive bond in an instance like this would be inappropriate, as he's still abused.
Split the puppy.
Okay.
I'd do it at 5.
Thank you, Judge.
So, but you got to understand, I am now also going to revoke your bond on the assault case, and I'm also going to make that 5,000 as well. So now both will be at 5,001. You now know what's expected of you. We don't mean business. I'm going to take you into custody now so that you know that we mean business. And the next time you do anything, we will have a hearing to hold you at no bond. Do you understand, Mr. Kennedy? So hopefully this is enough of a wake-up call for you to realize that we mean business. So do you mind filing conditions on the VPO so that way if he files,
Yes, Judge.
say no contact, no weapons, anything else?
No contact, no weapons. I believe the Moab, would you like them to mirror the Moab? So there's also the residency restriction. I know that complaining witness is currently staying with her sister.
Does she want the residency restriction?
I'll ask her before I put it on.
Ask. And if she does, then I will, because I'm going to do what she wants. But if she's okay with not, then
You get a sister's residence you'd be asking for.
Yeah. Okay.
Okay, guys. So we're going to take him in now. Well, I'm going to set the bond now. So I'm sure you have a bonding company now.
Yeah.
I'm sure you'll make it within the next 5 to 8 hours anyway. So it's not like he's going to be there forever. But just please impress on him that next time it's okay.
Okay.
So don't send him down though, please, guys. Guys, thanks.
Oh, maybe we otherwise need keys.
Oh, yeah. You know what? I'm going to do a new MOAP on
BPO? Okay.
APO.
Okay.
All right, I'm not muted. My face is up on the screen, and I got it paused, so it looks like I got everything right. In an hour and 13 minutes, me and ATX Alley are going to do a show called Court Addict featuring ATX Alley. It's going to be on American Courts 2. The link is pinned. A more important link is the link for Lena's to get to Houston. We got to get her to Houston so I don't hear about it anymore. So it's really important that we get her to Houston. If everybody could donate and get her there, I don't have to talk about it again. I don't have to hear about it again. It'll be great. Everybody will have fun. She'll take a lot of pictures and videos for us all. All right. We'll see you over there in an hour and 13 minutes. All right. Thanks, everybody.